Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 123 of our podcast. Thank you for listening. Thank you for your support. Listening for pretty much over 2 years now. Hope the information that I provide to you is helpful to you and your business. So, as you know, I'm a litigation attorney. A good part of my practice is business litigation, and talk about different aspects of the litigation process. Talk about trial preparation, trial cost. I talk about subpoenas. I talk about different subjects. So today I want to talk something that is very important, and sometimes it is missed, or and it can make or break your case. So today I want to talk about how to prepare for your deposition. If you're a party to a lawsuit, whether you're a defendant or a plaintiff, I want to talk about how to prepare and give you some tips of what to do, but also what to avoid as well. So for the next few minutes, I want to talk about that. And why is this important? Because the information that you provide at the deposition can be critical to your case, or it can help your case. So let's start from the basics. What is a deposition? Deposition is basically you're going to be answering questions under oath. And the questions will be asked by the opposing party's attorney. If you're the plaintiff, it'll be asked by the defendant's party's attorney. If you're the defendant, it'll be by the plaintiff's party's attorney. The objective of the deposition is to gather information, to gather evidence. And if you're the opposing party, it'll be to gather evidence against you. So this is very important. The objective is to get admissions from you, to get contradictions, to get inconsistencies, to get information that may not be available in the discovery at the time, to get you to admit certain things that might not be in your best interest. So that's what I want to talk to you about. It is a court proceeding, even though it is done in a court reporter's office. Now, lately we're doing depositions via Zoom. It is just as if you're in court, meaning that your attorney cannot help you throughout this process. Before you have the deposition, the attorney can talk to you. During the deposition, the attorney cannot speak to you. It cannot help you throughout the process. You are on your own. So that's what is very important to prepare for this depo, and I want to talk about that as well. So in this deposition, you're going to be, if it's a live depo, you're going to go to either an attorney's office, a conference room, or in a court reporter's office. The court reporter sits on one side with the recorder, and also with the typewriter that they use to transcribe your words. And also you're going to have the opposing counsel attorney on the other side asking the questions, and you'll have also your attorney as well present if you are represented by counsel, which is, I highly recommend that you have an attorney when you have a deposition taken. I would not recommend in any way, shape, or form that if you are a deponent in a case that you do it with an attorney present. It's very important. And there are a lot of reasons for that, but you want to make sure you have an attorney with you representing you if you are being deposed. There are a lot of rules of confidentiality, privacy. There are a lot of objections that can be made, and you will not know what objections to make. But your attorney would know that. So it's important to do that. If the depo is done via Zoom, which now most depos are done. In fact, I think I've only done 2 live depos in the last 5 years. When I say live, in-person depos, they're all live. And it's because it's so convenient to do it via Zoom or video technology. In this particular case, say you're in your home or you're in your office, your attorney might be in the same place or in his office in a remote location. You have the co-reporter as well that feeds in the video, and then the other attorney as well will be online. There's some advantages to that. Obviously, one of them is convenience. You don't have to travel anywhere for the depo to be taken. I like video depositions better because it allows me to present the documents on the screen, and it's easier to see them on the screen versus having to bring a box of documents in triplicates to a deposition. So I got to give one to opposing counsel, one to have for the deponent, and then one for myself to be able to ask questions. And then those copies are provided to the co-reporter that he or she will prepare the transcript with those documents. So it is a lot more convenient. So I like it better. It is my preference. And also in real time, I can react. In depositions, sometimes it's not the questions that you ask and you have your outline, you have your everything prepared. It's sometimes the deponents say something that is different than what you were planning on. It goes a different direction. And you might have to look for a document right there in real time that you did not have planned at the moment. So being online allows me to go ahead and look for that document in real time or during a 5-minute break and bring that document into the deposition and be able to ask questions accordingly. When you are in a in-person depo, you can do it, but it's a little more difficult, but then you have to email to the co-reporter to make a copy of that. It's just a little bit more cumbersome, the process. So there are the two types. You have your in-person depo, and then you have your remote depo as well. So, and again, I guess if I would say the advantages of having the in-person depo is that you can see a better reaction when you're there face-to-face rather than from the screen, and you can, it's a different dynamic altogether. So everybody has their preferences. The deposition is on the oath. So when you have your depo, the co-reporter will ask you to present your driver's license to identify you. You're going to be taking an oath that the co-reporter will administer, saying that you will answer the questions under oath truthfully, and then the deposition will begin. The depo will record every single the co-reporter will record every single word that you say. So it is important when you answer the question, you answer audibly and clearly, not with nods or sounds, simply because those types of gestures will not be able to be clearly identified in the transcript. And you might have also an issue that the video depo might be actually be video recorded as well. So in terms of, maybe backtrack a second, you want to dress professionally. You don't have to dress in a suit, but you certainly want to dress professionally so that way you have a good presentation in your deposition as well. So just remember that. What your opposing counsel is looking for, what is the other side looking for? They want to make sure that your testimony is locked in, that whatever questions they're asking of you, you have it locked in so that way they can use it for a summary judgment motion, or they can use it at trial in the case that they need to impeach your testimony or basically show you that what you're testifying live on a trial is different when you testified at the time of your deposition. So it is important that you understand the question that you're asked, and because whatever he or she's asking of you, it is designed to be used against you. So I want you to remember that as well. They want to test your memory, and we all do it. They want to test the recollection of the events based on the representation of the other side. They want to test your confidence in your demeanor as well, whether you get rattled easily or not. So it is important to prepare for your depo. And one of the things that I do before a deposition, I do have a depo prep meeting with my clients, and we'll go over the facts. We'll go over the type of questions that may be asked. In some cases, I'll ask them to listen to some of my podcasts that I go over some deposition topics just to give some refresher and get some tips on how to prepare. One thing that I would advise you is not to argue with opposing counsel. And I've seen that before, that the deponent gets upset. And granted, it's not a pleasant experience to be deposed. So nobody's going to, nobody's going to enjoy it. But you can be professional, but trying to outsmart the attorney, trying to, like a better word, be a smart ass, and trying to, make comments about the type of questions they're asking, and being, the word I'm looking for, being someone condescending to the attorney is not going to reflect good on you, especially if it's in a video deposition that they can play that back to the jury or to the judge. So just treat it as be as professional as you can. I think in that way, nobody's going to say you had a bad depo because you were professional. You were, just be professional in your deposition. So how to prepare for the depo? Let's go into that. Okay. It's important for you to know, if you're the defendant, why you're being sued. So you read the complaint and go over that with your attorney, and understand what is the basis for the lawsuit. Whether it's a breach of contract claim, whether it's a fraud claim, whether it's a partnership dispute, whether it's whatever allegations there are in the complaint. Understand why you're being sued. Understand what the other side, the plaintiff, needs to prove in order to prevail. You need to understand the lawsuit, because the questions will be based on that. The opposing counsel will try to elicit answers that will help his or her case. So understand that. Read the complaint. Read the answers and affirmative defenses that were raised. A lot of affirmative defenses are legal affirmative defenses. So have your attorney explain those to you, because you're going to be asked to explain the facts which support affirmative defense number 1, for example. And it might be a legal defense, and you may not have an answer for that. But understand what is on in those documents, what was drafted and what was filed with the court as a defense. If you filed a counterclaim, you're suing them back, suing the other side back. Read the counterclaim. Understand why you're suing for, what you're trying to obtain, because you're going to be asked questions about this counterclaim. Discover responses. And that's where your case, you can make or break your case. If you responded to discovery, you responded to interrogatories under oath, read those very carefully, because you will be asked about those questions. You will be asked about the answer you provided in your interrogatories. Review your contracts. Any contracts that you have signed that is part of the lawsuit, review them. Review emails as well. Text messages. Invoices. Any business records. And I know it can be overwhelming, and it can be a lot of work, but this is your case. And if you're not familiar with the documents that you signed or that you provided, or the text messages or the emails, they're going to come back later and haunt you. So being familiar with those exchanges, being familiar with those documents, being familiar with those text messages are important. And if you have any questions about the types of those documents or the significance of them, have your attorney explain those to you. You can say, what do you think they're going to bring up in the deposition? What emails you think they're going to bring up against me? How will this hurt me? How will this help me? Having the candid conversation with your attorney is very important. If there's any documents, review the documents that you provided to your attorney in response to the request for production of documents. Okay? Review that. And because it's very important. The reason for that is that those documents most likely will be used in your cross-examination. They will be used most likely in your deposition. So you don't have to memorize all these documents, but you have to be familiar with them enough that, yes, you've seen them before. And if it's a question that is asked which a document will refresh your recollection, you can say so. So, you know what, I remember seeing that document, but I need to look at it to be able to answer that question. Do you mind putting it on the screen so I can review it and then answer the question that you have? Okay, it's not going to be a test that you're supposed to memorize every document. So your attorney can help you with that as well. If there's any document that you have that has not been produced and you remember, so I remember, yeah, you know what, there's an email that I forgot to produce, or I found it. And that happens very often. That some people, because they have these deadlines to produce a certain set of emails, contracts, documents, text messages, and something gets missed. Okay, we have a duty to supplement. We have a duty to provide information that we later find that is discoverable, but is also responsive to a prior request. So tell your attorney, you know what, as I was preparing for this meeting, I found this other email that I don't think I sent to you. Here it is. Your attorney will look at it. If it's not a privileged document, your attorney will send it to opposing counsel and explain the situation that we found this document here. It was not produced before. We apologize. Here it is. Do that before the depo. Opposing counsel will look at it, most likely say, thank you, I got it, and move on. Because most likely, if you have that piece of that document, the other side may already have it as well, especially if it's a two-way communication. The last thing you want to happen is that you have a document presented in the screen or in person in your deposition that your attorney has not seen before, and that your attorney has not had the opportunity to discuss with you in advance. Because at that point, you're completely on your own. Because your attorney has not seen it before, you have not discussed it with your attorney, and you're there in a deposition, your attorney cannot help you during the depo. So it's important that if you find any new information, any new piece of paper or documents that were not answered properly, were not included in the responses to the discovery request, that you provide that information to your attorney so your attorney can forward it to opposing counsel. A deposition preparation is very important. And usually, my depo preps usually take about 45 minutes to an hour. We go over the facts, we go over the case. We discuss some of the types of questions that most likely will be asked, taking the role of the opposing side. So there really should not be any surprises as to the questions that you are expected to receive, a question that you're going to be expected to be asked at your deposition. So that's very important. If there's areas of the deposition that you feel uncomfortable with, whether because you feel this private, it's confidential, maybe embarrassing admissions, my recommendation is to discuss that with your attorney before the depo. Because the only time that you do not have to answer a question in a deposition is when your attorney instructs you specifically not to answer the question. And I repeat that. The only time that you don't have to answer a question in a deposition is only when your attorney instructs you not to answer the question. Otherwise, you have to answer each and every question that is asked by the attorney who's taking the deposition. What are instances for that your attorney will ask you not to answer the question, and what would happen after that? I want to spend a few minutes talking about that, okay? And I want to give you an example that is very obvious, but for the sake of this conversation, I want to make that example. If the attorney asked the question, what was your conversation with your attorney on this day? They're not going to ask the question. They shouldn't. If they do, they can be sanctioned, but that's attorney-client communication that cannot be asked. Another question is, why did you discuss with your spouse about the case? The attorney most likely will say objection. That's marital communication privilege. You're not going to answer that question. Okay? There might be other more gray areas. For instance, if it's a trade secret, that they're asking you a question that's considered a trade secret, your attorney may ask you not to answer that question on the basis of a trade secret, and there might be some discussions between attorneys, and what would happen in this case is that the attorneys will most likely go offline and discuss how to handle this particular question. If the attorneys do not come up with an agreement how to answer the question, whether it's going to be answered or not, and the position is still the same, then the attorney who's taking a deposition can certify the question. And again, this applies whether it's trade secrets, confidentiality, privacy, and people may claim some privacy issues. They may not exist, some confidentiality issues because they feel the matter is confidential. They may not exist. But for whatever reason, the attorney has instructed you not to answer the question. So if the attorneys cannot come up with an agreement in how to handle that, whether or not it's going to be answered at the depot or not, then what would happen is the question will be certified. And that will go throughout the depot. So say you have a number of certified questions. So then the attorney who's taking a deposition will file a motion with the court, a motion to compel deposition, testimony on the certified questions, and then a hearing will take place. The judge will determine whether or not those questions should be answered or not. And the question can impose sanctions to you as the deponent for not answering the questions if the judge feels that those questions should have been answered at the deposition. So there's a risk of not answering questions, but the instructions on not to answer a question should be reserved for very, very specific items. A couple of either additional tips that I want to give to you, okay? It's important that you tell the truth in your depot. It's very important. And in fact, if you are saying something that is not true in the depot, you can have serious consequences to perjury, but also the deposition, the whole case can be stricken and you can lose the case. I found that you actually purposely lying in the deposition. Number two, if your attorney knows that you're not telling the truth, your attorney has an obligation to stop it and making sure that clarify the record. So your attorney was not going to allow you, should not allow you to intentionally lie in your deposition. And in fact, if that could create a great deal of conflict, your attorney also could end up withdrawing from the case if that's the case. So you have to be sure that if it's something embarrassing, something that you're not comfortable with, tell your lawyer to see how your lawyer wants to handle that piece of information, okay? There are many different ways. There are protective orders. There are different ways to handle something, but certainly do not lie in your deposition. It's very important. Don't guess in your depo. You're asked to answer the question under oath to the best of your knowledge and belief based on what you recall that day. If you're not sure about something, say, I just do not remember, do not recall, but don't guess, and certainly do not try to help the other side. Answer the questions that are asked, and that's it. Don't try to expand further in your depo if you don't have to, but certainly answer the question. Pause before responding. it's important to take a pause to allow your attorney to decide whether or not he wants to object to the question or not. Don't rush the answer. Speak clearly, but also allow the attorney to finish his or her question first before you provide your answer. So that way you're not speaking over the attorney. The court reporter will not be able to properly record your answers. At times there's silence in your deposition. This happens often when I'm taking a deposition. I'm looking for an exhibit. I'm just, going through my notes. Don't let silence intimidate you. Happens often that when you have you have silence, then the other side the opponent begins to answer something that was not even asked. So that happens often. Okay, this is good for you. I'm probably going to do a second section of this in the next episode. But if you want to reach me, if you have any questions about any topics that I talked about today, my email is rich@richsierra.com. Again, it's rich@richsierra.com. You want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. My phone number is 866-842-5202. You want to watch the video of this podcast, it is at youtube.com/@RichardSierra. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.